The Supreme Court is the final court of appeal in the United Kingdom for civil cases and for criminal cases from England, Wales and Northern Ireland. It hears cases of the greatest public or constitutional importance affecting the whole population, including disputes relating to devolution. The court usually sits in the Middlesex Guildhall in Westminster, though can sit elsewhere and has, for example, sat in the Edinburgh City Chambers, the Royal Courts of Justice in Belfast, and the Ty Howell Building in Cardiff. The United Kingdom has a doctrine of parliamentary sovereignty, so the Supreme Court is much more limited in its powers of judicial review than the constitutional or Supreme Courts of some other countries. It cannot overturn any primary legislation made by Parliament. However, it can overturn secondary legislation if, for an example, that legislation is found to be ultra vires to the powers in primary legislation allowing it to be made. Further, under Section 4 of the Human Rights Act 1998, the Supreme Court, like some other courts in the United Kingdom, may make a declaration of incompatibility, indicating that it believes that the legislation subject to the declaration is incompatible with one of the rights in the European Convention on Human Rights. Such a declaration can apply to primary or secondary legislation. The legislation is not overturned by the declaration, and neither Parliament nor the government is required to agree with any such declaration. However, if they do accept the declaration, ministers can exercise powers under Section 10 of the Human Rights Act to amend the legislation by statutory instrument to remove the incompatibility or ask Parliament to amend the legislation. As authorized by the Constitutional Reform Act 2005, Part 3, Section 23, the Supreme Court of the United Kingdom was formally established on 1 October 2009 and is a non-ministerial government department of the Government of the United Kingdom. Section 23 of the Constitutional Reform Act limits the number of judges on the court to 12, though it also allows for this rule to be amended to further increase the number of judges if a resolution is passed in both houses of Parliament. It assumed the judicial functions of the House of Lords, which had been exercised by the Lords of Appeal in ordinary. The 12 judges appointed as members of the House of Lords to carry out its judicial business as the Appellate Committee of the House of Lords. Its jurisdiction over devolution matters had previously been exercised by the Judicial Committee of the Privy Council. The current President of the Supreme Court is Lord Reid. The creation of a Supreme Court for the United Kingdom was first mooted in a consultation paper published by the Department of Constitutional Affairs in July 2003. Although the paper noted that there had been no criticism of the then current law lords or any indication of an actual bias, it argued that the separation of the judicial functions of the Appellate Committee of the House of Lords from the legislative functions of the House of Lords should be made explicit. The paper noted the following concerns. The main argument against a new Supreme Court was that the previous system had worked well and kept costs down. Reformers expressed concern that this second main example of a mixture of the legislative, judicial and executive might conflict with professed values under the Universal Declaration of Human Rights. Officials who make or execute laws have an interest in court cases that put those laws to the test. When the state invests judicial authority in those officials or even their day-to-day colleagues, it puts the independence and impartiality of the courts at risk. Consequently, it was hypothesized closely connected decisions of the law lords to debates had by friends or on which the Lord Chancellor had expressed a view might be challenged on human rights grounds on the basis that they had not constituted a fair trial. Lord Neuberger of Abbotsbury, later President of the Supreme Court, expressed fear that the new court could make itself more powerful than the House of Lords Committee. It succeeded, saying that there is a real risk of judges arrogating to themselves greater power than they have at the moment. Lord Phillips said such an outcome was a possibility, but was unlikely. The reforms were controversial and were brought forward with little consultation but were subsequently extensively debated in Parliament. During 2004, a select committee of the House of Lords scrutinized the arguments for and against setting up a new Court. The government estimated the setup cost of the Supreme Court at £56.9 million. The first case heard by the Supreme Court was Hum Treasury v. Ahmed, which concerned the separation of powers. According to Phillips, its inaugural precedent at issue was the extent to which Parliament has, by the United Nations Act 1946, delegated to the executive the power to legislate. R.